Hi. This is the fourth episode of our talks about dispute resolution in California. In this episode, our guests Antonio Valla and Lisa Shockney from San Francisco, California, will share their views on how to be prepared for potential litigation in the USA. They'll explain why companies should get adequate insurance cover for their products, how to start a lawsuit in the US, and why you should always insert an attorney's fees provision in your contract. Make sure you follow Legalmondo on LinkedIn and YouTube to stay updated on the next episodes.
Okay. Hi, Lisa and Antonio. In this fourth episode of our talks on dispute resolution in California, after sharing your views on litigation in court, arbitration, and mediation, let's focus on the main things one should consider in US litigation. And maybe let's start from you, Lisa.
Thank you, Roberto. The first thing that I always tell our foreign clients to consider is adequate insurance coverage. That is an issue that we've seen come up time and time again. And the reason for it is that a lot of foreign companies have insurance coverage. It's just not enough. That's because a lawsuit in the US may end up costing significantly more than a lawsuit in a foreign country. The value of a human life in the US, and I know this sounds weird because the value of the human life is it's invaluable. But the reality is if there's a lawsuit and there's a human life at stake, or there's a loss of ability to do something, loss of use of your hands, loss of a leg, whatever it is, it may be more expensive in the US. The damages may be much, much higher. So where a $2 million insurance policy may be sufficient in Italy, that may be entirely insufficient in the US. The plaintiff may be asking for $10 million. And if the plaintiff wins, they get a verdict for $10 million. And your insurance policy is only $2 million, you would be responsible for that remaining $8 million. For many companies, that's a bet the company type of verdict. In other words, if you're responsible to pay out $8 million, you may not be able to operate your company anymore. You may not have sufficient funds to do so. And so insurance coverage is essential, having adequate insurance coverage. And the general rule of thumb that we advise companies is to have coverage for at least half of your revenue, half of whatever revenue you have in the US. The way to do that is also through umbrella insurance policies. So you don't necessarily need your primary policy to be half of your revenue, but you should at least have an umbrella policy that would cover or make up the difference. Some other things to consider when you're thinking about insurance is how high is your deductible? If your deductible is $150,000, realize that if you get sued, you're probably going to be paying that $150,000 in order to meet your deductible. So make sure that that's something that you can afford. Finally, there's multiple types of insurance policies. There's obviously general liability insurance. But in the US, if you have a US company and you have employees in the US, we recommend, particularly in California, a insurance policy called EPLI insurance. It's Employment Practices Liability Insurance. California, specifically New York, some other states are known to be very friendly towards employees. And often employees know that, they sue their employer, and general liability coverage will not cover those types of cases. And so you'll need a specific coverage policy called EPLI. And so those are just types of insurance policies to consider when you're thinking about adequate coverage over your US companies.
Good to know. Thank you, Lisa. How about you, Antonio?
I just wanted to spend a couple of minutes on the topic of service of process. So a lawsuit is filed in the United States, in California, and it needs to be served. In other words, your company in Europe needs to be notified of the filing of a lawsuit. And in many cases, US lawyers are not familiar with serving foreign companies. And they may try and effect service by ordinary mail. So it's very important that if you receive, or your client receives, a package of legal documents from the United States by ordinary mail, that they do not reply to that document. Because US courts are very practical and they say, well, if service was effected by ordinary mail, normally it would not be sufficient. But if service is effected by ordinary mail and it was actually received and the person to which service is addressed responded, then service is effective. So from a client perspective, if they receive anything resembling a lawsuit, they should not reply and they should consult with an American lawyer right away, because there may be issues of procedures that can be dealt with. If the plaintiff's lawyer, on the other hand, is more sophisticated, he or she knows that the world is divided for the purpose of notification of judicial acts into two broad categories. The countries that are signatories to the Hague Convention on process, and the countries that are not. The countries that are not signatories to the Hague Convention, service is very complicated. It needs to go through diplomatic channels and can take months and months and months. For signatory countries, on the other hand, there's a streamlined process, which is still lengthy and somewhat complicated, but it's streamlined. In the case of Italy, for example, service can be effected through the central authority. In Italy, by the central authority in the United States. The legal documents need to be provided in the original language, as well as need to be accompanied by a full translation in the predominant language of the country where the defendant is located. And if you go through all of that, then service is effective. The message here is to beware. Do not try to avoid service by not picking up the mail. Simply receive it, whatever it is, consult with counsel, because if there's a way of keeping you out of a lawsuit because service is defective, that needs to be addressed immediately and evaluated immediately.
Okay, thank you. What about litigation costs, Lisa?
Yeah, and litigation costs piggybacks off of my first point regarding insurance, because litigation in the US is expensive. The costs are expensive whether you are filing a lawsuit, so you're on the plaintiff side, or you're defending a lawsuit. And a large portion of those costs are seen in the middle of a lawsuit. It's called the discovery phase. There's three main phases in the lawsuit. There's the initial phase, and that's really, the complaint, service of the complaint, as Antonio just talked about, and trying to dismiss the case if you're on the defense side, if you can. And then starts the discovery process in the lawsuit. And that is the longest, and it costs the most money other than trial. The way discovery works in the United States, it's very different than many other countries. And discovery in the US is really extensive. You basically can ask for almost anything you want that's related to the case. And if you don't provide it, it cannot later be used during trial. So there's no such thing as trial by ambush in the United States, like there is in other countries. And so because of that, it's a costly process. Trial is also costly, but often cases don't go to trial. As we've discussed in other series, most cases are mediated, many cases settle, really because the cost of trial can be so expensive. But I don't want to leave you with fear. I'd like to leave you with some tips that would help mitigate potential litigation costs going forward. And the first tip is really having adequate insurance coverage. If you have an adequate insurance coverage and a low deductible, if your carrier kicks in, they're really paying for the costs of trying the case if you're defending yourself. The other tip I have is always have attorney's fees provisions in contracts. We've discussed that before. That means if you're successful in litigation, whether it's on you're bringing the case or you're defending the case, then you can at least recoup those costs later. Having arbitration clause, Antonio mentioned, I think in our first Q&A series, the importance of an arbitration clause, and then we talked a lot about arbitration. That helps mitigate the costs of litigation. And finding opportunities to dismiss the case early on, whether that means filing a motion to dismiss for lack of service or lack of jurisdiction. And then finally settling a case early on, if appropriate, doing early mediation, talking with the parties, seeing how you can resolve this case before it gets too expensive.
Okay, thank you. Antonio, the last question is for you, and it's an important one. How to find the right lawyer in the US?
Well, of course, the answer is you get in touch with Legalmondo and select from our group, right? But I don't want to be facetious about it. It's a very important question. I am a little bit of old school about it, and I think there are three fundamental elements. A lawyer acts in a fiduciary relationship, and therefore, in my view, there needs to be a human and personal connection between the lawyer and the client. I mean, even if the client is a large company, there needs to be a good personal connection. He or she needs to be somebody whom you feel on a very instinctual basis, you feel you can trust. That is predominant. The second thing is, I believe the lawyer, particularly in situations involving foreign defendants, needs to be culturally sensitive. And what I mean by that is he or she needs to be able to bridge the cultural barriers, be able to express himself clearly, be able to explain concepts using, I don't want to say simplified English, but using non-legal English, because it's very difficult for a client to be under stress in litigation, and on top of that, not understand his own lawyer. So the cultural ability to deal with other clients, which is not just language, mind you, it really is the ability to open your mind and think about how your client receives your communication, is fundamental. And the third thing is really communication. And that means that the client should come to an agreement at the beginning of the relationship as to who will be his point of contact. It's very common in American law firms, and I think in European law firms as well, that there's initial point of contact with a partner, and then the case somehow gets passed around the office to other professionals, right? Now, we all work in teams, and I'm not saying that we shouldn't, but I think the constancy of communication, the single point of contact, the clarity of communication are fundamental. The client will be asked to provide information, make decisions. Some of those decisions are potentially dangerous, expensive, and can expose the client to further liability. So unless there is clarity at the cultural and factual basis, the choice would not have been a good choice. Do your due diligence in advance.
Excellent points, Antonio. I couldn't agree more. And thank you for bringing them up. And I think this is a good place where we can wrap up. Thank you both. And until the next episode, goodbye.